Right. So today we will continue with the polity, right? So as we discussed before. So the first topic. So powers of governors. So this is one of the hot topics what we have, and you know that even Supreme Court had many observations regarding this, right? So how far this particular what do you call the Supreme Court observed? So what all the powers have been tested in the court of law? So questions can be in that particular area. Okay. So can you tell me what are the powers with regard to floor test for governors? Whether they have discretionary powers or not. So how or what it is all about? Anyone at a time? First.
Oh, yes, sir. So the topic of flow test was in news because of the Bihar government issue that had happened recently. And like you said, it is under the discretionary power of the governor, and Article 163, I mean, it does not explicitly mention it, but we can derive it from that. And so if the governor feels that the government has lost, or if it is suspected that they have lost the majority of the of the house, so then the governor can ask for a floor test.
Okay. Okay.
And it's like a confidence motion or a trust vote that the government will put forth.
Okay. Okay. Then any other regarding floor test?
Sir, without floor test, governor should not dissolve.
So in case of any issues of loss of confidence in the house, then actually a floor test should be conducted. Otherwise, governor cannot suspend the legislature. Okay. Then anything else? Okay. See here with regard to floor test, you have two things. Okay. So what you need to remember is that floor test before dissolution. Okay. So when he wants to, when the governor wants to suggest a report the union government about dissolution, definitely floor test has to be conducted. Number two, whenever a new government comes to power, okay, so usually the floor test will happen. Okay, so the previous one is floor test which is done with respect to check whether that particular government is having adequate number or not. Okay, because of certain political crisis. Usually a new government will have a conference motion, a floor test will be conducted. So anyway, it is going to be a symbolic, but still it is going to happen, especially when there is a fracture verdict. Okay, when a minority government are there or some fracture verdict is going to be there. So naturally there will be some issues, correct? So these two are there. So when a government enjoys majority, okay, in the floor of the house, without any issues, the government doesn't have any right to ask for a floor test. But when there is some issue, say for example, a group of MLAs coming to the governor or going to a speaker asking that they are not supporting the government, kind of. So if there is a doubt, if that particular government doesn't have sufficient numbers, then he can ask for a floor test. Okay. So remember that usually governor directs the government to undertake a floor test, and they will not interfere in the procedure of the house, because the procedure of the house will be carried away by the speaker, so who will not be intervened by the governor. But at times, say recent example, Karnataka previously, that is before the previous Congress government had Yediyurappa issue and all. So at that time, governor even directed at what time it has to be done and so on. But generally, it will not be done. So it is just overreach by the governor in this particular aspect when he intervenes in the procedure. Okay. So remember that as president, governor is also a part of the legislature, and he is considered to be the head of that particular legislature when he is presiding. But the procedure and all, the conduct of the house, the final authority goes with the speaker. Okay, so understand the role between speaker and governor. More time, this is the point of dispute which happens between legislature and the governor. Okay, so then chief minister versus governor in exercising the discretion. Okay, so that will be another point of dispute politically and administratively what it is. Got it? So in these areas, there can be questions which can be asked in prelims as well as mains. Okay. So in this regard only, the doctrine of pleasure of ministers comes in. So whether governor enjoys doctrine of pleasure on ministers?
No, sir.
Yes, sir.
Yes. Whether it is absolute, whether he can
it's not-
suspend, I mean,
no.
do away with that doctrine of pleasure.
No, like on the advice of the chief minister only.
So it is not on his discretion. Say, yes, doctrine of pleasure applies, but not on his discretion. It is only aid and advice of
Chief ministers.
chief minister. Okay. So similarly, for president also, only with the aid and advice of the prime minister, your cabinet ministers and other consular ministers and union government is appointed. Same way here. So who has to be a minister, who has to be removed as a minister? It is only the purview of CM or prime minister in the union. Okay. So that doctrine of pleasure doesn't directly vest any discretion on this particular case. So even suggestions are not advised from that particular part of governor to the chief minister. Okay. Usually, governor or president, constitutionally, they are not entitled to provide even suggestions with regard to ministers because it is purely the purview of the discretion of the chief minister and the prime minister respectively. Clear? Understand that. That is one. Because that was also a dispute in a state like Tamil Nadu, where chief minister wanted a person to be say even if that particular thing is amount to constitutional morality kind of, governor can send a message. Okay, so constitutionally, morality wise, say this may not be good, but still, since chief minister advises, so he'll be getting into that aid. So he may have a note, but he cannot go against the decision of the chief minister in this regard. Okay, so that note, yes, definitely he has his own authority to do so. Why? Because he is a guardian of the constitution at the state level. Right. So because he is the head of the state, so naturally he has to protect the constitution. So he can note it, but unfortunately he cannot stop it because it is completely the discretion of the chief minister. Remember that difference. Okay, that is a slight difference what you have. And similarly, with speaker and all procedure of the house, it will be undertaken by the speaker and it will be the discretion of the speaker according to the rules and procedures of the house. Okay, governor can direct something with a message, what can be done, what need not be done. Got it? So this is a relation between these. So these two are very simple and it is very categorically mentioned in the constitution also. Okay, fine. With respect to first legislature, I mean, first assembly or meeting of the first assembly of the new government or every year. So constitution mandates the president and governors to address the respective legislatures. Okay. So what are the aspects in these governors address to a particular assembly? So what are do's and don'ts on part of governor? What powers the governor have while addressing a state assembly?
So ideally, the governor must follow what the advice of the CM and Council of Ministers.
Okay.
And should not act in his or her discretion.
Okay. Say for example, if that particular speech which is given, say usually the speech is prepared by the state government. Okay, there the Council of Ministers will provide it to the president. So in that particular case, in case if the government has a speech, and in that speech, if that particular government has a criticism upon itself, say for example, upon the governor himself. So what will happen? What is the position of governor there?
Like, even then he has to follow it.
Hmm?
I think he has to follow it even then.
How it will be? Say, I can't be critical on myself, right? So Article 20, Clause 3, which we saw last time, applies to governor also. He has the right to not to be indicted against himself. So
Right.
there is a case regarding that. Say where once when the same situation happened earlier, the governor skipped that particular word, which was critical upon him, right? So that issue came up to the court. The Supreme Court clearly gave an advice that yes, of course, one cannot be critical upon themselves. Okay, so naturally, that particular area alone, they have some discretion, not as a part of discretion, but by under as a fundamental right, they have to exclude that. Got it? So that is allowed. But you cannot get rid of the entire address. You cannot skip that entire address in that particular manner. Got it? Understood? Self-indication alone can be exempted, but otherwise, the state the Indian advice has to be there with respect to the address. There is no change which is allowed, which he doesn't have any right to have any change because it is his government which has been providing it. And understand that before that itself, there will be a conversation between the governor and the state with respect to what is the address is. And in case of any reservation he has, he can always place them during that particular conversation. But when it comes to the address is completely the discretion of the government, and it is the duty of the governor because he is just a titular head. The real head is the government. So naturally, he has to read whatever it is, and same applies to president. Got it? Right. So this is one part. And remember that, yeah.
Sir, one doubt, sir, like I usually have, sir, like suppose in constitution something has been written and like Supreme Court, suppose like for the floor test, many times it has happened like governor has like dissolved the government without even conducting the floor test. Supreme Court has like in the judgment he has barred that law. You cannot do that. So is it possible that like a governor can overrule the judgment of the
Definitely not. Definitely
okay, so
not.
whatever the Supreme Court has said, that is the
Yeah,
final.
they have to. Yeah. See, the thing is, Constitution is the what do you call it? It is a guiding soul, right?
Yes, sir.
So you need to abide by the rules and regulations which are prescribed by the Constitution. If it is not so, naturally the governor or the president can be removed. No doubt about it, because they are the guardian of them. Number two, sometimes this constitutional wordings may be interpreted, and that is where we have the role of Supreme Court comes in.
Yes, sir.
Right? Supreme Court is important in this particular aspect because they are the only person who can interpret the Constitution and declare what is law.
Yes, sir.
Clear? So when they are going to declare what is law, so naturally it takes Article 13, which provides that particular thing is also a law under the constitutional aspect. So that is also, unless or otherwise, something is amended in that particular judgment or anything new amendment is done by the Parliament, until then, Supreme Court observation or that particular judgment will take the precedence. Understood?
Got it, sir.
So you cannot overrule that just because it is Supreme Court judgment. It has to, even if it is president, they have to adhere with these aspects. Got it? Because they declare what is law. Fine?
Yes, sir.
Okay. And that is the importance of the, what do you call, the values of the Constitution is really important because, see, even recently CJI clearly identified that the Constitution is very important. Why? Because Constitution protects even those who actually doesn't believe in that. Okay, that is the actual spirit of the Constitution. Say, I may believe or not believe the Constitution, but within that particular territory, when Constitution is there, whether you believe it or not, the Constitution provides you certain things which it doesn't make any difference between believer or non-believer. Okay, so that's a spirit of the Constitution, any Constitution which happens to be. And this Constitution is interpreted, and whether that particular interpretation is right or not. So it will be declared by the Supreme Court. That is the sole role of Supreme Court, right? You may have any interpretations. The High Court can interpret, Parliament can interpret, anybody can interpret in any manner. But unless it is disputed, it will not come to Supreme Court. When there is a dispute and comes to Supreme Court, that interpretation what Supreme Court gives will be the final. Okay. In case we want to change it, you need to amend it and do it. That's all. Okay. But when it comes to interpretation, the interpretation until then it is settled with that particular court. That is the most important function of the Supreme Court there. Got it?
So Supreme Court is the So the question is, sir, like there are many interpreters, but in the case of dispute, the Supreme Court will be the final interpreter. Okay, sir.
I don't put the word final, sole interpreter, because finalization comes, say, for example, Supreme Court gives a ABC judgment, right?
Okay.
Some judgment called ABC judgment. And if generally the rule is that you will not outrightly remove that ABC and you incorporate a new amendment. Okay, Supreme Court had clearly identified that you can't just verbatim replace that particular judgment. Though the Parliament has a power to amend the Constitution, it cannot amend for the sole purpose that it can get rid of that particular Supreme Court judgment. Understood? So it cannot happen. But you can amend in such a manner that the spirit of the judgment is upheld, but certain mismatch can be done away with. Got it?
Sir, can you explain
Understood.
with an example, sir? Like, sir,
say,
like,
for example, simple. Take the election commissioner's appointment.
yes,
Now
sir.
the amendment has been done.
Yes, sir.
The constitutionality of the amendment is different. Okay, that is under question of law, which is still undecided. But now a judgment has been provided. What the judgment says? The judgment says there is certain ambiguity in the Constitution where there is certain lack of qualifications with regard to the appointment. That is the core idea of that particular judgment.
Yes, sir.
So you bring an amendment, giving certain qualifications, certain conditions, certain prescriptions.
Yes, sir.
And one part of the judgment is Supreme Court Chief Justice of India will be also a part of it, but the government has excluded that. A part
Yes,
of the
sir.
judgment has been excluded. It is not the complete idea of that judgment has been excluded. Got it?
Got it, sir.
That is, it is not completely against that judgment, but part of the spirit of the judgment has been done away with. Okay, the spirit of the judgment is done away with, no doubt about it. But it is not completely against that particular judgment. Understood? You can't go deadly against the Supreme Court judgment. Say, for example, Supreme Court says you cannot make a law in this particular aspect. Okay, if it declares that, you cannot say that you cannot amend that particular clause. Say, for example, Article 31. Say, under Article 31, you cannot do this particular law, make this particular law. If Supreme Court says, Parliament cannot just amend under 31, Parliament can enact law in all these aspects, which is diametrically opposite to Supreme Court's observation, because Supreme Court has given some reasons why you cannot make law. Got it? You cannot just do away with that entire judgment, nullify the entire judgment. But partly you can do, say, under the recent Supreme Court judgment, okay, fine. These are the conditions. So with the conditions, there are certain provisions which can be provided under Article 31. Yes, you can do it, no doubt about it. Understood the difference? You cannot
Yes,
completely nullify a judgment and go against with an amendment, but you can still do an amendment with the spirit of the judgment upheld. That's the idea.
Sir,
Yeah.
one question, sir. Like in 1986, like the Rajiv Gandhi, did like that, like he brought a judgment, like he brought a, he brought a law, like the judgment that has been given. Sir, can you explain where, like, what happened there, like whether it was totally against it of the judgment?
See, that's why at that time it was not a problem. Right.
Okay, sir.
So when things were happening at that time, it was not a problem. So when executives started doing that, then only the Supreme Court came up with the idea that you cannot just completely nullify it. Okay,
Okay.
so that became a habit. When Supreme Court gave an judgment, they started nullifying the entire judgment and enacting another law. Got it? Say, for example, best case is the rummy and the online gaming. When Tamil Nadu government came out with a law, the High Court struck down that particular law. Okay.
Yes, sir.
It said that, say, still you have the power to make a new law, but this part of this law is not correct. So you can pass a new law where that particular problem will not happen. Understood?
Yes, sir.
If the Supreme Court clearly say, or if the court has declared that state doesn't have any power to do so, the state cannot bring a new law.
Okay.
Okay, that is the
Sir,
idea.
like suppose,
Fine.
suppose like Supreme Court has said that you cannot do this. Can I do one thing, like can I go to Constitution and I amend that provision and then I can bring that law? Is it possible?
Yeah. See, that is where how it is going to happen. Say, for example, the Supreme Court will clearly mention them. Say, for example, last time we discussed the issue of the same-sex case, right?
Yes, sir.
In that case, what they did, they clearly mentioned that under this act, it is not possible. Tomorrow,
Yes, sir.
if the Parliament passes a law, then we can allow, we can check for that constitutionality whether it is allowed or not. Got it?
Yes, sir.
So Supreme Court will give a clear-cut standing. So it will not be ambiguous. So whether you can do it or not. So what will be the judgment and what is the consequence of the judgment and how the consequential amendments have to be done? That is very clear.
Yes.
Got it? That's the idea. Right? So understand that basic idea.
Understood, sir.
Fine. So this is doctrine of pleasure on ministers, the address and the floor test. As far as assent is concerned, so what are the powers? Recent court observations have been there. So especially with Punjab.
Their veto power, like president has a pocket veto. Does governor also has this same pocket veto power?
No. That was a recent judgment. Supreme Court clearly said that governor does not have pocket veto.
Okay.
Like I think so, like it was like you cannot hold for more than 3 months and
Yeah.
all.
So
something.
here it's not 3 months and all. They didn't have any time frame fixed because fixing time frame again will end up in a crisis. Why? Because when I give say 6 months or say 3 months or whatever, say 90 days kind of, 89th
Yes,
day I will do it. What I will do,
Yes,
89th day I will send back to the legislature.
Yes, sir.
Okay, so that should not happen. So as far as assent to bills is concerned, recent observation alone I explained because assent to bills, you know what they will do. So the recent judgment is very clear. As soon as possible. Okay, the word as soon as possible is as soon as possible. That is, even if today morning I got it, I can send it even by afternoon also. Okay, if it is possible, you can do it, not a problem. That is the word as soon as possible. And remember that when a bill, other than money bill, when a bill is put in place, okay, the governor as soon as possible have to take an action. What action he can take? Only two things. One, either assent the bill or return it back or reserve it to president. So only two actions they can do. So if it is reserved to president, then the governor's job is done, finished. Whereas the other said, if he is going to give an assent, not a problem. If it is going to be returned, that is also Supreme Court highlighted. If you want to return it as soon as possible. You cannot keep on holding. And when pressure increases, then you try to send it for reconsideration. It cannot happen. Again, it is as soon as possible. Got it?
Yes, sir.
So as soon as possible is absolutely as soon as possible, where it doesn't have any time frame at all. Clear? Even if the governor wants to consult, he has to consult as quick as possible, and he has to send that particular bill. And how the governor of Tamil Nadu said, if the governor doesn't give his assent, the bill is almost dead. It is a wrong statement. It cannot happen, and that is what Supreme Court also clearly indicated. Okay, governor cannot have a bill dead, and that is not the purpose of the governor to be there. That is what Supreme Court clearly identified. Clear? So here he can do only these two. Either reserve it to president if it is not in your jurisdiction, or if any contradiction is going to be there. if you are going to take decision, you need to either give it assent as soon as possible, or in case if you want to have reconsideration, immediately you need to send it for reconsideration. Now, what happens when the bill comes again without any amendment? The governor has to sign. So Supreme Court clearly said, after that he cannot use any other options. Remember that when the reconsidered bill is sent back, okay, without any amendment or with any amendment or whatever it is, the governor has to give assent. He or she cannot send it or reserve it to President under 200. That is also judgment which is, an observation which is made. Since it is not a judgment, we cannot finalize it, but the Supreme Court is very clear upon that. They cannot exercise other options, because if the governor wants to reserve it, the first instance itself, the governor has to reserve it. After reconsideration, they cannot reserve it to president. Clear?
Sir, can governor sir, suppose can he deny the assent? Is it possible that governor can deny the assent?
They cannot deny at all. Either they have to give assent or reserve it to president or send it back for reconsideration. If it is back, they have to again give the assent. There is no other choice.
Got it.
A bill cannot be dead, as simple as it is. That's the idea. Okay. Fine. And whether it is president or governor, elected government is always supreme. Remember that. That is also has been reiterated by the government, by the Supreme Court in various judgments. Titular head, when you compare titular head or elected government precedes. Say whether president or council of ministers or the governor, definitely the elected government will be having its higher say on a titular head. If it is governor, then again it is going to be titular head. So president, president itself is a indirectly elected post. For them itself, they say elected government is going to be supreme. Yeah. So the decision, that is the reason why we give aid and advice, which is importance. The due importance is given that. And for the governor, who is neither elected and it is just appointment and it is going to be a doctrine of pleasure of the president, definitely the elected government will take a superseding position in with respect to policies or administration, whether it is union territory or whether it is going to be state. Whether a union territory with small numbers like Pondicherry, 30 members, or whether it is Jammu and Kashmir, or whether it is going to be your national capital territory, which is special status. So all these things, elected government has a upper hand, because that's the voice of the people. That's a fundamental law. You don't change that. Even in interview, you can easily say that elected government will have a supremacy in a democracy. That's a very purpose of the democracy. Got it?
Yes, sir.
As simple as it is. Clear? That's the idea. Fine. Understood the issues of governance. So these are all the various aspects. They can ask you straight away what are all the provisions, what are all the discretion, or they can just say which one of the following are the discretionary powers of the governors or so on. All these things which can be discussed. The governors, Supreme Court clearly said governor have discretion, no doubt about it, but only in the prescribed areas of the constitution. Wherever constitution says there is a discretion, there only the discretion is applied, whereas fundamentally all other areas, aid and advice of the council of minister will be proceeding. Clear? Done? Any doubt on this? Any other questions in governor? Oh. Now, no confidence motion. Again, one of the most important thing. Last year it happened. Okay. So as far as no confidence motion, Constitution doesn't define it. Remember that we don't have anything in the Constitution. Yeah, with regard to confidence or no confidence motion. It clearly mentions that majority of the house is required for survival of the government, but it doesn't mention about what majority means and how it is going to be defined and so on. But only the rules of procedure has it, especially in 198 rule number in the procedure of Lok Sabha. Remember that no confidence motion, rules of procedure under Parliament, if they say it is not right. Rules of procedure under Lok Sabha only, because it is no confidence motion, which is only undertaken in Lok Sabha. Remember that. Okay. Similarly, who can give any? Is there any possibilities for a removal of governor? Yes, there is possibility, because Constitution clearly mentions the procedure grounds on which a governor can be removed, and how the governor can be removed. So it is doctrine of pressure. When the pressure is removed, governor will be removed. That's all. Yeah. So how it can be moved?
So my question is whether the elected government can put on
Definitely
pressure.
not. Definitely not. It is only president who can do it, and president will do with or without giving you any reason. But in case if the governor go against the constitution or the grounds are mentioned in that particular ground, you can. I mean, the concerned minister can advise the president to remove that particular government, right?
Okay, and in that case, if he goes against the constitution, can Supreme Court decide on the removal of the governors? Or if in case
See,
any
with respect to removal of governors, say especially remember that with respect to the constitutional positions, Supreme Court will not have any inclination to pass any orders. Okay, generally. Why? Because see, even today, when governors have this problem with the state governments, Supreme Court cannot issue a notice to governors. One, they have immunity, but still they will not be issued because it is a constitutional position which is going to be head of a state. So it will create a constitutional crisis. Clear. So that is the reason why you don't hold in that particular aspect, because today persons may come, persons may go, but institutions will stay, right? So Supreme Court will always think with the idea of institution rather than individuals. Clear. So it is a issue between individuals, right? So today there is a crisis with the government and the governor. It is not with the institution of government or the institution of governor. It is because of the individuals, right? True or not? So that's a problem. So they won't address it as individually. They will address it as institution. So they will be very careful in using the words, using the they will be very clear not to undermine the dignity of that particular positions. Okay. But beyond that also, there may be some criticisms coming on from Supreme Court on governors because of the extent what they misuse their power. Say, for example, in Punjab, the governor was seriously criticized or worded by Supreme Court in different aspects in the judgment. So naturally, that is really one of the image of that particular institution has been having a dent. But anyway, it happened because it happened in that particular issue. But generally, they won't do so. Okay. So Supreme Court will not interfere because definitely it will say the respective president or the other authorities will take care of it. In case if nothing is going to happen, then only someone is going to move to the Supreme Court, where Supreme Court will advise. That's all. Most probably they won't give any judgment kind of. Say even in this particular cases, what happened? So they try to ask Chief Minister and Governor to sit together and solve the issue. They cannot direct it, right? So when you start directing, you demean that particular institution. That's a problem.
So even
today it may be happy. Today it may be happier, but down the line it won't set a good precedence.
Yes, sir, got it. So even at any case, they can't be brought to the court to get any answer.
Say it is not that they cannot be brought to court. Definitely it can be brought to court, no doubt about it.
Okay.
But the thing is that they won't say for example, a governor is going against the law, okay, and president is not taken any action, and you have approached Supreme Court. Supreme Court will not say that governor is removed. Got it? Definitely, it will not happen.
Okay. Okay.
Right. So they will come down heavily upon the government, they will come down heavily upon the governors. They'll take up a chance to advise the president kind of. That itself is not good enough for the president to have that. Got it? Because these are three institutions which have to go in tandem, right? So definitely Supreme Court will not have it. Say even when Supreme Court came down with certain claims for exercising the powers of the president with respect to pardon, they clearly said the intention is whether it is malified or not. That is alone we are going to check. We are not going to check the powers of the president. Understood? They are very clear in wordings. Only the intention of the president is, that intention comes with the Council of Ministers. Council of Ministers is a political body. Got it? That route only they will take. They will not just clamp out or clip off the powers of president, which is described in the Constitution, which is not the job of Supreme Court, and Supreme Court cannot do that. Clear?
Yes. Yes, sir.
It is more than judicial overreach. Understood? So that's how the judgment should be. See, here also, even the Tamil Nadu government says that the timeline has to be fixed. Supreme Court will never fix that particular timeline, and it should not be fixed also. Got it? It will be detrimental in the coming days together.
It will be taken as an example.
Yeah. See, for example, you say within a month you need to do. If something is not fine and some mishap happens, so you will say why the governor didn't take any note of it. Got it? So that won't really work. So within this particular day, within that particular day, it has to be done. It is the responsibility of the governor to dispose the things as soon as possible. See, Supreme Court clearly says that you need to realize your position, you need to realize the dignity of your position, and you need to do it. Clear?
Yes.
That's what they are trying to educate. So they don't want to dictate terms, they want to educate. That's the most important aspect, and that has to be done. You can't provide a judgment in that way abruptly. Yes, within 10 days you need to submit, otherwise you will be checked out of job. It cannot happen, and it should not happen. And it's not the job of the Supreme Court, because it is a political issue where Supreme Court at the end of the day what may advise. Say Parliament has to take note of it. This is we advise the Parliament to take seriously on this and try to pass a law regarding that after a due discussion. That's what the direction they may give maximum. They will not fix it. But say if it can be fixed, naturally the framers themselves would have fixed, right?
Yes, they would have gone.
Certain things the framers had open thing because they thought that the position is dignified and the people who would be appointed would be dignified. That's a problem. But unfortunately, it didn't happen. Yeah. Fine. Anyway, so
Sir,
coming back to this, yeah.
Sir, like in Tamil Nadu, like sir, like I have read like the governor left without the reading the like. So sir, like, is it a violation of Constitution?
So it is not a violation of Constitution. It is a negligence of duty and negligence of the dignity. What it happens to. Yeah. That's a problem. See, the most important problem is that the governor says that the part of the speech consists of certain things which are against the Constitution, against certain things, but he never disclosed which part of the thing is going to be against the Constitution.
Yes.
If it is so, the government would have done that clearly. It would have been done so. Yeah. So that is absolutely, say, it is like it's my home where I am going to lead the home. Just because I have a problem in the home, I just run out of the home. So how it can happen? Because it's my home, right?
Yes.
How I can leave my home and go just because I have a problem here? It cannot happen, right?
Yes.
So same way, he is the head of the state, and if you have a problem within the state, you cannot just come out of that particular symbol of the state. It's your place, right? You need to put it in order. So you can't just run out of it and say that there is nothing called as this and that and so on. That's a problem. So this is a political problem, what it is. The political problem, at the end of the day, what happens? It tarnishes the institution. That is what Supreme Court highlights.
Yes. Yes, sir.
At the end of the day, institution is very important. Say today this person may be a governor, tomorrow someone else will be a governor, right? But institution of governor, the institution of chief minister, the institution of the legislature, the council of ministers have to be upkept. That values have to be upkept. That's more important. Anyway. So coming back to this, no confidence motion. So remember that no confidence motion is happening only in Lok Sabha. So naturally, when the word parliament comes in, be careful what sense they are going to use it. Okay, and it is not defined in neither the confidence motion nor the no confidence motion is defined in constitution by itself. And remember, any MP can give a written notice which requires 50 members. Okay, minimum 50 members. Any member of the Lok Sabha can be providing a written notice which has a 50 members of that particular house in support. Okay, and if the speaker is satisfied, remember, if the speaker is satisfied, usually the motion will be adopted within 1 or 2 days. Okay, generally, as per convention, when no confidence motion is accepted, no other bills will be discussed. It's a general thing, but unfortunately, last time it happened. Other bills were taken first. Last, only no confidence motion was taken up. Okay. Anyway, so this is what the thing is. So, how many days one can have a no confidence motion, and next to no confidence motion, what is a gap between that?
Sir, I think it is a 1 year gap.
6 months, sir.
6 months. Okay, it is 6 months. Okay, 6 months. Remember, if one no confidence motion has been initiated and taken up, the next no confidence motion can occur only after 6 months. Okay. So there is a concept called confidence motion. Sometimes the government itself will come up. Say you have it in the Delhi government as of now. Confidence motion will be there. So when confidence motion is passed, actually this is a new concept. It is not there in rules also. So it's just a extra thing what we had, having a confidence motion being passed, right? So remember that. And similarly, you need to have the absolute majority, then only the government will survive, otherwise they have to resign. Okay. Similar to no confidence motion also, you would try to have other motions where the government has to resign. So which one? Any idea? In case if that particular motion is not passed, the government has to resign.
The president's address.
Okay, president's address. Then vote of thanks for presidents. Okay, motion for vote of thanks of the president's speech. Then okay, annual financial statement. Okay, so the motion for demand for grants. If it fails, you have to resign. Then any other? Any other? What happens when adjournment motion is passed? Whether you need to resign? What happened? Adjournment motions. You need not. Censure motion you will have to. And policy cut. In case policy cut and other stuff, motion is passed. Again, you need to resign. So understand what are all the areas where you need to resign. Okay, that's important. Similar to this, I can ask you. Okay. So similarly, no confidence motion comes with Article 75, Clause 3, where they are collectively responsible. Okay, that is the reason this is provided in the rules of procedure. Okay, remember that Constitution doesn't define it. You don't. No confidence motion has a root in Constitution. That is 75 Clause 3. Okay, being defined is different. Being rooted is different. Say no confidence motion. If the question is worded in this way, so no confidence motion is undertaken as per the provision of Article 75 Clause 3. Yes, it is, because 75 Clause 3 says they are collectively responsible. When a no confidence motion is passed, they are collectively sailing, and if it fails, then naturally they have to collectively resign. Got it? The root comes from 75 Clause 3. So, but the definition is not provided. So, accordingly, the words will be there. Try to understand it and try to have it. So, they don't confuse with that no confidence motion doesn't have any provisions regarding that in Constitution. It is not defined, but provisions are there. So under which it is evolving. Provision is 75 clause 3. Got it? Fine. Oh. Anyway, so you can have some facts here. So Kriplani had the first no confidence motion moved and so on. So this
Sir,
you
do we
can.
need to remember all these facts?
Do
we need to remember all these facts if it is
See,
like
not necessary as of now, but just it's not remembrance. It is just a skim through, which will help you in sometimes in case of extremely they would have asked. So you can just have a chance of elimination, right? So that's all.
got it?
Not much. Then comes your special session. So what is special session? Again, this is not defined in the Constitution. Special session. So as the name indicates, it is a special session. So something special is going to happen. So you have a session for that in the Parliament. Okay. So usually it can be of specific occasions. Okay. So something which is very important across the nation. Say for example, GST. For launching of GST, you had a special session which was convened. Both the houses had a thing. So you don't have anything defined in the Constitution regarding that. And similarly, you don't have any fixed set of calendars for that special sitting. Clear? Fine. Remember that special sitting of the House, the word is there in the Constitution. This is important. Okay. Under 44th Amendment Act, there is a word special sitting of the House. Got it? So that is emergency provisions for Article 352. So that alone, there only cabinet alone, the word comes there. Special sitting occurs only once there. It is under 44th. Apart from that, you have other sittings, which is not a problem. Sitting means convening that particular day. For that particular day, we call it a sitting. For that entire season, we call it as a session. Okay. The entire season, we call it a session. Say winter session, monsoon session, budget session, like this. Sitting means individual day. Whenever the Parliament is convening in a single day, we call it a sitting. Okay. So one day of affair, we call it a sitting. Anyway. So apart from that, you can see whenever we had this particular special session, yes, we had special sessions which are there. These are certain areas where we had special sessions, especially in recent times, we had 3. Okay. The last decade, we have 3 occasions. So one, adoption of the Constitution, we had that 75th anniversary. Then we had GST and new Parliament building. So for 3 times, we had a special session in the recent past. Okay. Apart from that, we had other 9 of them, which is usually for commemoration of independence, Quit India movement, kind of. Okay. Not much in other aspects, but only in this particular way. 2 important things you need to remember. One is special session for Indo-China War, Sino-India War, and then this one. Emergency for state emergency for extension. Rajya Sabha had a special session in 1977. Apart from that, almost again 1991. These are all just to know that there are special sessions which are happening in this way, because a question can be there, marking some event to extend president's rule, to extend an emergency or implement of emergency. A special session can be convened. Yes, it can be. For a trust vote also, a special session can be convened. Okay, so it can be a commemoration of event. It can be some emergency declaration event. It can be introduction of some new taxation. It can be there is policy issues. It can be even trust vote kind of. Okay, any other inauguration, any aspects it can be. So special session of a Parliament can be convened in which one of the following? It's almost all that. Got it? Remember that special session is different from joint session. Okay. Yeah.
Sir, like you said, like a special sitting, like so Indo-China War, like 352 has been imposed.
At that time, it was no. In 1962, it was special session to discuss about the war, right? So that was the thing
Can
which was
it
conducted.
happen also like to discuss like although special sitting is mentioned, so can we have a special session like if it suppose Article 352 is going to be imposed in today's time, can we have a
session means session means combination of 2 or 3 sittings, that's all. 2 or more sitting, we call it a session.
Yes, sir.
Right. So it can be 1 day affair, can be 2 or 3 days.
So basically, what was the purpose of like mentioning a special sitting in like in 44th constitutional amendment, sir?
Because say simple, because usual session is this. That's what we have mentioned here also. Usual sitting is this one. Okay, budget, monsoon and winter. Okay, if you want to convene about say when you are having these months, you will do all the business of the house within that particular time. In case if you want to do something immediate, but you are not in session, so budget session is done, finished. Okay, so within June, one things have to be done. You can wait. Usually, we will wait up to July. So the next session will begin with. After that, we will do. No, it can happen only now. What will happen? So okay, we will have a special session. Say for example, the Jallikattu law in Tamil Nadu was passed in a special session. Why? Because at that time the budget session was not there. The monsoon of winter session was also not there. But you need to pass a law to diffuse the crisis. So what happens? There is a special session which is convened. A law is enacted. With that, the entire thing is done. Just 1 day after. Got it? But it is a special session. Why? Because you are not in budget, monsoon or winter. You are in separate set of convening. That side. Got it?
Yes, sir.
Done? Okay. So any question on special
sir,
session?
still just
understood that?
The confusion that I have, so suppose 1 day special session has been called for, like 1 day, like we have called a special session for only 1 day.
Yeah.
So
Even
is it
for
a
half a
special
day, you
sitting
can.
or a special session?
See, usually we call it a session because it is going to be whether 1 day or 2 day, because it is outside a particular session, right?
Yes,
say session is nothing but the entire duration of that particular convening of the parliament or legislature. Okay, sitting is one particular day, we call it a sitting. That's all. One sitting can also be one session, or one session can also have one sitting. One session can have 2 sitting, 3 sitting, n number of sittings. Clear? Done?
Yes.
Okay. Fine. So then the caste survey which happened in Bihar. So that is another news. So here they won't ask you about the content of the survey. If they are going to ask you, they will be asking you the difference between these 3: census, JC, CC, that is socio-economic caste census, caste survey. Okay. Remember that census will fall under Census Act. Okay. This is a legal process which is undertaken under a statute called Census Act. Okay. So it is undertaken by the Office of Registrar and Census Commissioner, so and so, under Ministry of Home Affairs. Whereas socio-economic caste census doesn't fall under the definition of Census Act. Remember that. Okay. So it is not under the actual Census Act definition, because it doesn't define in this particular manner, but still we did it for certain purposes of undertaking socio and economic status of a particular group of people. Whereas caste survey which is undertaken, so these two will be undertaken only by the Union of India. Okay. Whereas the caste survey which can be undertaken, they will be conducted as a survey, not caste census. Okay. By the state. If the state is undertaking, it is going to be survey. How? Through Statistical Act 2008. Remember that these surveys are undertaken not under Census Act. It is Statistics Act 2008. where the state is empowered to collect any fact regarding anything, social, economic, whatever it may be. Got it? So that Statistics Act only you are going to undertake this survey, which is under Article 340, where they want to get information about this social education backward. Understood? So the statement will say, recently, Government of Bihar released a caste survey undertaken under Census Act of 1940. That is wrong. It should be taken only under this particular act. Clear?
Yes, sir.
Right? So this is a fundamentally one important question which you need to understand. So otherwise, nothing much is important in this aspect because they won't ask you in this particular case. Okay, but it is a first such state-wise entire exercise has been undertaken this time. Okay. Previously, though, we had other states which we had, but still a large scale entire state, it is first time which has been done. Okay, so this is a simple thing which you need to remember there. Then the most important part is tribunals. So as part of tribunals, recently Armed Forces Tribunal ordered that or directed the government to settle some issues with regard to pensions and so on. In that, Supreme Court was approached. Supreme Court clearly says that tribunals cannot direct governments to make policies because tribunals are not higher courts, that is High Court or Supreme Court. They don't have the status of High Court or Supreme Court to direct the government to make policies. This is again important. You need to remember Article 323 and all. So read 323A and B. So under 323 B, for all the various areas where you can have tribunals, where you can have other administrative tribunals under Article 323, and what are the other tribunals we can have under 262. Okay, so we can create three tribunals, three different types of tribunals. Okay, 262, 323A and B. Okay, so understand that. So try to have this particular case remembered, N.K. Sharma case, with respect to tribunals. It had clearly defined what their status are. Okay, so remember that they are quasi-judicial body, they are not completely judicial body. Okay, so since they are not completely judicial body, they cannot undertake this particular function. They can just resolve problems, but they cannot direct the thing. And remember, tribunals are not part of the original constitution because they came up with the amendment 323A, 42nd amendment. Clear? So these are some of the areas what we can discuss today. And in the next class,
Article 262 mentions about the tribunal. So was it not part of the original constitution?
Yeah, it is not actually tribunal, right? So it is just adjudicating conflicts. So here the name we put it as Interstate Water Dispute Tribunal and so on. Okay.
Yes, sir.
But technically speaking, tribunals are defined in this particular area. Okay.
Okay.
Or in case if you can put it in this way, the original constitution provides tribunals only to resolution of adjudicating disputes with respect to river water, interstate river water. Whereas for other part of the tribunal, it is only through the amendment we had. Clear? So
Yes,
that's
sir.
a thing. And here also under Article 262, tribunals are not provided. It empowers to provide a tribunal. Got it?
Yes.
Here 323 directly provides tribunal, whereas here it is not. Okay. So in this particular case, it is also empowering provision only. So you can't strictly speak that tribunals are really part of the constitution. Clear? So that's a idea what we can have. Anyway. Yeah, Supreme Court can direct the government to make policies. No doubt about it, because one, under Article 142, so they can do the complete justice. So the power is undertaken from that only, Article 142. Otherwise, it goes with the judicial overreach. There is judicial activism, we call it as, but under 142, it can intervene in the policy decision also. Clear? 142 is a very powerful provision. which Supreme Court usually doesn't use, but they have used quite often, and that's the reason they have given guidelines also. Okay, with regard to recently also they have re-emphasized the guidelines with regard to 142, how it should be used and for what cases they have to use. Okay, so that we'll discuss later. So 142. So if recently, I think in January they had it in 2024, right? So 142. So this particular tribunals and other aspect we can be asked with questions, because rationalization of tribunals also happened now, and also this particular judgment has also come up. So naturally, for that reason, you can have it. Clear?
Yes, sir.
And remember, administrative tribunals, they have the power of only civil court. They don't have the power of the criminal court. And that's the reason why they are having less powers. Okay? They can have the powers only exercised by a civil court. Yeah. Right. Okay. So any other questions with regard to these?
No, sir.